somebody who's only got 5 employees. I mean, I'm not talking about if they're part of a bigger picture. I'm talking about a sole proprietorship, somebody who's got their life savings in it. Why should they be? They don't have money to go hire some attorney to review. The retainer would cost them more. A lot of times they're getting a letter threatening them on some kind of a lawsuit because they didn't do something, and so they find themselves having to cut a check for $1,000 because it's cheaper than going out. And there are attorneys that do that. Right. I'm dealing with one right now that's doing that kind of stuff. So, what is wrong with just for the little guy?
I totally understand from the employer perspective what you mean about different needs and a different kind of landscape. I think what's hard for us coming at it from the worker perspective is that worker is no different whether they work for a company with 20 employees or whether they work for a company with 5, and there are pressures on workers, especially in this kind of environment. But in general, we're an at-will state. Workers, it's every worker's job to keep their boss happy. And so if you're told, hey, we really need everybody to stop getting overtime after 8 hours, we want everybody to go to this alternative work week, there are people who have family commitments, who are single parents, who just simply can't make it work. And I think we're struggling to figure out, how do you build in protections? That doesn't mean there's not ways that potentially things could be simplified or clarified, but how do you build in protections so that workers aren't retaliated against or coerced to give up a really essential basic right?
But see, that's the whole point. See, the small business people, they're just saying, God, this is just too complicated for me. 8 hours, that's it. Sorry, you can't go to your kid's game. You're here 8 hours, then you can go leave. Okay, but that's what I'm saying. You keep going back to the big business cases, but even when when somebody talks to you about the little guy,
right,
you're still not willing to even consider making some kind of exception, or even some kind of, let's say they go file their little written agreement. Just if they make a mistake, then let them have a grace period or something. But you're not willing to go there at all.
I think that there are many areas here where there's room to talk. I just think, just kind of as a threshold thing, it's a hard thing to say. Does that mean that any worker can be called in one-on-one and told, this is the way things are going to be? I think it's just hard to figure out how you structure worker protections absent an election.
You do realize we've been talking about this for quite a few years that I've been here. Okay, you are aware of that, right? I mean, look, back in 1999, I know exactly what the political landscape was here, and I know why those acts came about, and I know all the frustration that was bent up over the 16 years prior to that by organized labor. I understand all the reason why those things happened. So do you. So does most of the people in this room. I don't care about that. It is what it is. What I do care about is you've got a lot of small businesses people out there, and I'm not talking about the 100.
No.
Okay, I'm talking about the little guys out there, and they're being impacted to the point that they're losing their homes and they're moving. The state is in a huge recession, and if we don't get serious about at least allowing the little guys, the ones that don't have any big corporate agenda or anything like that, the ones that are just trying to stick it out here that could actually provide maybe a job for somebody, if you don't do that, they're shutting down too. And they aren't there. And then where are you at? I mean, you got no job, okay? They can't afford the attorneys. Okay.
Senator Dutton, I hear what you're saying. And, two things come to mind right away. First of all, I think it is worth noting, for what it's worth in terms of fear of lawsuits, that a small employer like that is not going to face a class action lawsuit because they're not big enough to have a class. So, to have a class action lawsuit, you have to have
enough. You are aware of what's happening right now, what happened with the Trevor Law Group out of Texas, what's happening right now with ADA violations. No, there are attorneys out there that are sending these letters out threatening people.
Okay, I'm thinking more in terms of, the wage and hour area, and in terms of that. I understand what you're saying on that. In terms of the wage and hour area, I think most typically with small employers like that, their employees, if they have an issue, they don't end up going to court. They end up going to the labor commissioner, and the employer and employee have this little hearing in front of the labor commissioner where the average...
What's the problem with putting that into as a provision for them to do? I mean, so that you do protect them. If that's what they're doing anyway.
Because the reality is that's exactly what's happening now. The labor commissioner, the average hearing in the labor commission, the average decision, and this came out in a Supreme Court decision that mentioned this, is between $5,000 and $6,000. They're small cases, and more typically than not involving small employers. That's really the one thing the Labor Commissioner does very, very well, and really has been its historic role to be a place where employees who otherwise couldn't go anywhere can have their claims heard, and where employers, aren't going to risk this huge exposure to attorney's fees and the like. That's the thing.
Well, I'm just telling you what's really happening out there, and it's, believe it or not.
Yeah.
I want to thank Caitlin for being willing to talk about it. I really want to, Miles, was wonderful seeing you defend attorneys. I have some empathy. I sometimes try to defend politicians, and I just, in the spirit of the original comments, if there's a way for us to work with it, I find myself agreeing with Senator Dutton on some of this, although I've since, with all our pay cuts, I've since started doing consulting, and I have a client in San Francisco in the restaurant business, and it's the cumulative effect. I don't think, in that instance, I'm trying to think, well, they have to pay the hour when they do split shifts is probably the weirder thing for the restaurant business. But it's probably more access to capital, I would say, that's killing the mom and pop restaurants. Having said that, if there's a way to do this a little bit more efficiently for those, that's my perspective, and if we can do that, and you can continue the other fights as far as I'm concerned, and you probably will, and Senator Dutton will probably submit another bill, but in regards... Well, it depends who that one is. As long as we exempt plaintiffs' attorneys, that'll be fine. So if we could just continue the discussion, I think that'd be really helpful in that framework.
If I can just sort of conclude by saying that, I do understand, I think, what Senator Dutton is trying to do, and that is to keep as many businesses and jobs in California.
No, it's impossible. Well, it's a bunch of communists.
I guess Senator Dutton was reminding me about how terrible San Francisco is. But what concerns me, Senator Dutton, is exactly, I think, what Caitlin is talking about, is that while you reference the little guy, there's also the little guy on the side of the employees, where they do, in fact, feel tremendous pressure to accommodate an employer, and that if you then shift to this alternative, and that if I am a single mom or a single parent, and I've got to take care of my kids after they come home from after-school program, and I've got to make dinner and so on, then what am I going to do? And if this is a job that I've had for 10 years, and I know this job well, I know this industry well, it's going to be hard for me to then say, well, okay, I can't do this alternative, and I'm going to put myself out in the market. So I think that that's where, I am very, very sensitive about that. But with that said, it seems to me that there's got to be some clarification of the rules and regulations about, how you establish the alternative work, and then how do you, keep it functioning, so that at least if there is an agreement of the affected units, that employers moving forward are not going to find a gotcha situation. Okay. I think the other is, if there is a way, Senator Dutton, that in your 5 staff company scenario, if there is a way to kind of make sure that there is not undue pressure on workers, that if you don't comply, then you're gone, that kind of situation, so it seems to me that there, with good hearts, that there's got to be a way of coming to some conclusion, and so that's what I would support. Okay,
that's a good conclusion. I'm going to end it right there. Thank you very much. Really appreciate it. Oh, I'm sorry. We have public comment time. I can't end it. So I take that back when I have public comment.
But you have to represent 5.
Am I allowed to comment?
Yes.
Hi, Senator.
Sorry about that. Okay. Go ahead. If you could state your name for the record.
I'm Betty Jo Tacoli, and I am president of the California Small Business Association. And this is an issue that is very near and dear to our hearts. But I want to start by giving you the profile of our members. Our members average 16 employees, have been in business 12 years, and their gross revenues are $3.5 million. I have a suspicion that that 16 employees has gone down. But from our small business advisory councils, this comes up very often. And so we ask small business owners in this from our membership to go to the Department of Labor and find out how to do this. The information is just not available. They didn't know what they were even talking about. Now, maybe they didn't use the right words. So education is one thing that is very definitely needed. But nobody was referred to the website. They all came back and told me there wasn't a process to even put in the application. So I wanted you to know that. And I want to volunteer that I will work with Caitlin across the state on an education project. So that would be our pleasure. And I want to tell you why this is so important to the small business community. We want to cut employees' costs. We want to cut their gas costs, their child care, the environmental impact. So we do want to cut employees' costs. We also want them to have more consumer spending. We use college students, and quite often they can work 10 hours in a day, and they'd like to work 10 hours because they need the money. We're not going to hire that second employee, but we would give them 2 additional hours, and that would be additional consumer spending. So my goal and my recommendation is let's simplify the process. Let's make it easier to do. Let's make it fair to employers and employees, and let's make this state grow and shine again.
Thank you. Appreciate it. Go ahead.
Good afternoon, Mr. Chair and members. Connie Delgado with the California Hospital Association, and just want a couple of brief remarks. While many view California hospitals as healthcare providers, we're also major employers in most of your districts. That is true. California hospitals employ over 500,000 people and are the largest employer in many communities. Because of the 24/7, 24 hours, 7 days a week dynamic patient care environment, hospitals, California's restrictive workplace laws pose particular challenges. Additionally, the current statutory scheme that encourages class action litigation has had significant impact on hospitals. Many of California's workplace laws are either ambiguous or not well suited to the patient care environment. And as a result, California hospitals have had to spend millions of dollars in defending and in many cases settling these lawsuits. 2 major areas of inflexibility and ambiguity are meal periods and alternative work week schedules, and we've heard a lot of discussion about that today. And while the Brinker decision will address many questions that have arisen with the meal period, it will not address all questions. And for example, one issue that is of particular importance for our hospitals is the circumstances of which an on-duty meal period is valid. For example, can an employee have an on-duty meal period when he or she is assisting in surgery or the birth of a child? It may be feasible to relieve that person to take a meal period, but it may not be in the best interest of patient care. And many hospitals are reluctant to use on-duty meal periods because the parameters are not well defined. Implementation of an alternative work week schedules are also an area of concern for our members. Many hospitals use alternative work week schedules because the employee's preference or operational benefits. While the intent of alternative work week schedules was to provide flexibility, the reality is that the implementation of such schedules currently exposes employers to the threat of costly litigation. Areas of ambiguity include the definition of regular schedule, and some plaintiffs' attorneys are arguing that this requires an employee to have a schedule that is defined by particular days and hours an employee will work in a work week. However, in hospital staffing, it's very complex, and thus assigning particular days to an employee is very difficult. Moreover, many hospitals are using self-scheduling, and this provides employees with flexibility. All of these areas of ambiguity mean hospitals have to spend precious dollars, many, many millions of dollars defending these types of cases and litigating these types of cases, and dollars which we believe would be better spent on patient care and making sure that those resources are used for the patients in the state, and that everything will work in the best interest of all the parties, patients, employers, and employees. And we would look forward to legislative changes that will really address these concerns for workplace flexibility. Thank you very much.
Thank you. And we're also happy to take written materials for the file as well.
Okay. Great.
Yes, go ahead.
Briefly, Mr. Chair, Chris McKaylee on behalf of the California Grocers Association. Just a few quick points. One is I think that we seek CGA maximum flexibility for our workplace and our employees, and I think as the employer panel outlined, there are significant limitations that restrict our flexibility and our ability to manage our respective workplaces. A few points from the last panel. One was a statement that somehow an 8-hour workday will benefit employment. I think we're all familiar that at current 11.9%, we're a full 1/3 higher than the national average at the rate of unemployment and the second highest in the nation. There was also a statement from the prior panel concerning how an 8-hour workday ensures safety in the workplace. And of course, I would note that since 47 other states follow a different set of rules, I don't think that we are alleging that there are unsafe work environments in those 47 other states. The last panelist indicated some information about the 8-hour workday. Perhaps I misunderstood, but the implication was that the rule was effective in 1999. Of course, we know that the IWC work orders were effective at least from 1980, and when they were changed effective 1/1/98 by the IWC, of course, those were statutorily then changed, those 5 amended wage orders in 1999 under AB 60. Lastly, on PAGA, again, perhaps misinterpreting the last panel statements, of course, the attorney's fees are not just contingency, i.e. a percentage of the plaintiff's recovery, but in fact, under PAGA, they can apply to the court for statutory attorney's fees. I would, in closing, draw to your attention, I think, what Ms. Barrera cited in her background, the Obama White House study. They noted that American society has changed over the last half century, and I think they concluded with a statement that it is critical for the 21st century U.S. workplace to be organized for the 21st century workforce. And so in light of the topic or the subject of this hearing, I think CGA's perspective is that California law should be, in fact, brought into the 21st century. Thank you.
Thank you. Go ahead.
Hi, my name is Katie Mendoza, and I work for Bishop Weiscarver. We're a U.S. manufacturing company. We're family-owned. We've been in business for over 60 years. We have about 51 employees, 14 which are union. We regularly solicit our employees, and they've been asking for a flexible or alternative work week for the last year or two. And they all have actually, we had about 30 people come forward and sign their support for an alternative work week. Being a small business, we do have a struggle with resources and have found the process to be cumbersome and have shied away because of more of the liability reasons for it. We always like to treat our employees fairly and always pay them overtime and do the right thing. And for us to have some flexibility or a way to work within the law or clearer guidelines, that would be beneficial for us. So I'm here to show the support of our employees and of the company.
Thank you.
Thank you.
Thank you, Chair and members. My name is Dorothy Rothrock with the California Manufacturers and Technology Association. I just have 3 brief points. One is, since this is a California-only policy, I think we should be regularly reviewing it to make sure that it's meeting the needs of the economy and not holding us back in any way, because companies do look at these policies to determine where they're going to site or expand their facilities. We had a German company call the CMTA within the last year, and their main problem with the thought about coming to California was the labor rules around overtime. So it is a real consideration. It's not just impacting folks that are here now, but folks who are thinking about coming here. So we ought to be looking at it very closely. In terms of competitiveness, you know, you've heard it all. We are having a tough time here in California. A recent study was just described in the media within the last day or two by City Journal, using a National Establishment Time Series database, has found that between 2000 and 2008, 80,000 more jobs left California for other states than came here from other states. And that's a flip from the 10 years prior to that. So we're seeing a shift in the economy here that's in the wrong direction, in the negative direction. Finally, another point that hasn't been raised yet, or at least when I was here it wasn't raised, the environmentalists are looking at reducing vehicle miles traveled in order to achieve greenhouse gas emission reduction goals. We have Senate Bill 375 that's asking local governments to look at their policies, transportation policies. Alternate work weeks and other kinds of flexible work schedules can allow commuting to happen at times to avoid congestion. Perhaps shorting the work week, having 4 10s or something, you save one commute a week. We've got a lot of federal agencies who are doing flexible time policies, partly because of environmental reasons. This was just a brief scan of the websites that I did. I haven't got anything scientific about it, but I do think there's an environmental component here that we should be looking at as well. Thank you.
Thank you, Mr. Chair and members. I'm Matt Sutton, the California Restaurant Association. Thank you very much for the hearing. It's an issue of great importance to us and has been, and as a result, you've heard lots from us over the years. So I just have a few quick points, and I will keep them quick. It seems in the face of double-digit unemployment, lots of bipartisan interest in regulatory reform, sense of how do we do things in a more streamlined manner as a state, and some sensitivity to the costs of regulations and existing laws to businesses and to the overall economy. There seems to be a great opportunity to look at this, and I appreciate the sentiments that have been shared here. As far as I know, right now, the restaurant industry is the second largest private employer in California. This issue actually comes up a lot with our members in terms of we survey them and we ask them, what are the barriers to growth? In our industry, as you can imagine, with such tight profit margins, there's not a lot of growth going on right now, and people are hanging on. But people are looking to the future, and they are looking to grow, and this issue does come up as an impediment to growth, and we hope not to recovery. But we think there's a way to set up a system that works well for the employee. The employer allows employees to choose their hours, allows employers to accommodate flex schedules without the fear of an employer having a technical or procedural slip-up that exposes them to legal uncertainty. So I think, consistent with all the comments made at the dais, thank you, Mr. Chair, and other members, but we think there's a sweet spot here, and we'd like to find a way to explore it with you as time goes on.
Good afternoon, Mr. Chair. My name is Randy Knott. I'm with the California Hotel and Lodging Association, and I also represent the California Association of Bed Breakfast Innkeepers. So you really have the largest spectrum, talking about the largest chain hotels down to the smallest mom and pop folks who actually live in their workplace and invite others into their home. Speaking of home, apologize. One of the reasons I went into local government for the first half of my career was it was one of the only places at the time, and this was back in 1991, where they were doing alternative work schedules. It was something that was a quality of life issue. It was worth making a decision that perhaps you wouldn't make as much money in the private sector, but you would have a quality of life. In a lot of cases, that is something that people really do need to negotiate, especially with two-parent families. When you're looking at hotels similar to hospitals, although certainly not quite as important, we are a 24-hour-a-day business. And some of the most important events in someone's life can happen there. And we're also one of the keys to recovery in California. As tourism goes up, we're slowly but surely rebounding from what we've been dealing with. And we do want to hire more people. However, these kinds of rules make it very, very difficult. And there are times when folks will actually choose not to keep an entire floor closed rather than deal with some of the things they need to deal with. So we'd love to see this conversation go on. We certainly appreciated Senator Dutton's bill because it would affect our CABI members, and we appreciate the hearing and look forward to being part of the conversation. Thank you.
Tim Lynch on behalf of UPS, and in the spirit of cooperation that's been talked about in large part here today, to thank the legislature for its work on AB 569 relative to meal and rest period, and look forward to working with this committee and others on SB 316, an Emerson bill that will further advance meal and rest period for part-time workers in the transportation industry under a collective bargaining agreement. So we thank your work in that narrow slice. I know there's also hope that there's a greater fix that occurs in the meal and rest section. Thank you.
Good afternoon. My name is Eva Nunez. I don't have a business. I I'm an employee. I work part-time. I just have something to read here. Being supporting mental health clients with disability acts at work. I just like to introduce this as a mental health client. No matter what your education level may be, doing your honest performance, you may be surprised. Lower education, housework, farm worker, child care, restaurant, car wash, Goodwill. This type of employment, nurse's aide, and on. The lower uneducated person may do very well in their work. Many have done very well. Employees of higher levels, state, county, city, or license, working alongside of all this is a honor for myself and others. The state law must be legal rights to speak. I believe that legal rights in the United States, people should know English and respect all of us. All of us, women and men in institution, should have their disability, social, employees work and meet needs. Employees should perform adequate work performances under the Social Security. How should it be with the insurances, health, and normal concerns of employees and employers under the federal law? I just like to say that when you're on Disability Act, it's hard for people to work because you're in the disability. You're kind of disconnected from all this. When we have a problem, we have to go to the side. We have to go to the rehab. If a person is working at Target and you're under the Disability Act, all your insurances and everything go to the Disability Act. I believe that when the state constitution makes more adequate laws for disability people and institutions, our rights would be more adequate in our work performance. A lot of the people are married, have children under Social Security, but when you take Social Security mixed up with Medi-Cal and their disability check, it makes a lot of conflict, and sometimes that's what causes all these issues we're including today. Thank you very much.
Thank you very much. Appreciate it. This concludes the hearing. Thank you. And I didn't hear anything.